convene the Milimani Law Courts Court Annex Mediation Bar Bench Committee. So today's in today's instance of court, we are going to discuss court annexed mediation. What is it, what it entails, together with the newly gazetted court annexed mediation rules. Before we start, some housekeeping rules. Kindly mute your mic or switch off your video if you are not one of the speakers, just to keep it very orderly. Then we want to have a very interactive session. So feel free to post your comments, reactions. You can even greet each other in the comment section. Then we shall have a plenary session after the speakers have finished their presentations, because your question might be in the content of the next presenter. So we shall have a plenary session after all the speakers have finished their presentations. But if your question is very burning, you can post it on the chat section, or if you feel like you might forget your question, you can post it on the chat section also. So today we are very privileged to have a panel of very eminent persons. We have two judges of the Court of Appeal, and we have an acclaimed international mediator who also happens to be one of our court annexed, one of our accredited mediators with the court annexed mediation program. So before we even get into exactly who our panelists are, what is mediation? Of course, we all know that mediation is a form of dispute resolution that is grounded on Article 159, Article 2, Article 159, Sub-Article 2, Paragraph C of the Constitution. And mediation is a form of dispute resolution where parties are, with the help of a third party, known as the mediator, they are guided through specialized communication techniques to get a solution. So mediation is a solution by the parties, for the parties, through the guidance of a mediator. So when the new constitution was enacted, of course, under the article that I have just mentioned, that is Article 159. Article 2, Paragraph C, it provides for various forms of dispute resolution, and mediation is one of those. And we know that court annexed mediation was piloted in the year 2016 at the Milimani Law Courts in only two divisions, that is the family division and the family division and the commercial division. But since then, the program has grown in leaps and bounds, as we shall hear from one of the speakers. And initially, there were no rules, there were just practice directions. So that is a bit of the background regarding court annexed mediation. But to kick off the discussion, we have a panel of three speakers. As I had mentioned earlier, we have two judges of the Court of Appeal, that is the Honorable Justice Odunga and the Honorable Justice Ochieng. We also have an acclaimed international mediator by the name Rosemin Banji. However, our first speaker will be Justice Ochieng, Justice Frederick Ochieng. Justice Frederick Ochieng was admitted to the bar in the year 1982. He was appointed as a judge in the year 2003 and has served in various stations. And he was very recently elevated to the Court of Appeal. Now, Justice Ochieng will talk to us elaborate on the role of the Court Annexed Mediation Task Force and its role under the new rules, because we are aware that the Court Annexed Mediation rules were gazetted in October. Over to you, Justice Ochieng.
I'm told that you have not given me permission to show my face. But it's all right.
Let's see, admin. Yes. Karibu sana, Judge.
Now you've given me permission. That's the way he looks. Good afternoon, everybody.
Good afternoon. We confirm we can see you and we can hear you loud and clear.
Thank you very much indeed, Angela. First, I would like to begin by saying a very big thank you to the committee led by Angela. The Bar Bench Committee between the Nairobi chapter of the LSK and the judiciary based at Milimani is very vibrant. They have helped the mediation task force, the mediation secretariat, in reformulating rules from what we used to use to what has recently been gazetted. And therefore, the rules are not the work solely attributable to either the task force or to the judiciary. It is as a result of a combined effort with the members of the bar. And I would like to confirm that whenever they made contributions during the sessions and in writing, they definitely were a very sober group of people. I would like to confirm that they did not sound like they came from the bar. Now, what is the role of the mediation task force? Both before the launch of the rules in October and going forward, even after the launch of the rules, the main role played by the task force is to ensure that mediation grows, that the roots of mediation get better anchored, and that everybody, if possible, gets to know that this is perhaps the best thing that can happen when people are in dispute over any matter, except, of course, the matters that are strictly of a legal nature, which requires interpretation of the law, or matters which the law says are not amenable to mediation. So our role is to roll out mediation to all court stations in the country. So far, we have rolled out mediation to 89 court stations. We would have liked to have rolled out to many more, but when Corona came visiting, everything literally ground to a halt. So that really put a halt for a long time to our rolling out of mediation to other courts. But you will be glad to know that the latest we have set as a goal for ourselves to roll out mediation to each and every court in the country is 2024. So we have a lot of work to do ahead of us. We are thrilled that we now have the undivided support of the LSK. They are both working as advocates representing clients at mediation sessions, as well as being mediators themselves. So the very brilliant ones, that's what I call them, are the ones who continue handling in court through litigation the matters which either are not amenable to mediation or in which mediation has been tried and has not succeeded. So those you continue with in court. And if possible, when you have done that in the morning, if you properly organize yourself and your time, in the afternoon, you can be a mediator. And in mediation, you know, the results are a very happy group of people who are hitherto in dispute. Happy because it is they themselves who formulate the resolution to their dispute. And yes, before you actually get involved in active mediation, many lawyers will ask the question, but wait a minute, some of the legal issues have not been dealt with. They have not been addressed. That is not what mediation is about. Mediation is not about determining the legal issues. It is more of finding a solution to the dispute. So many times it is addressing the underlying factors which led to the dispute arising in the first place. And because the parties formulate their own solution, so far since the year 2016, when the pilots started, there has not been a single need to execute any mediation settlement agreement which has been adopted as a judgment of the court. Why? Because the parties themselves have agreed on what the solution is, and what you agree to, you know, usually you are able to achieve. And therefore, the biggest job that is still left to us is roll out mediation, talk to the people, both lawyers, non-lawyers, their clients, their administration, so that people find mediation acceptable and meaningful to their lives. This is very, very important because one of the new rules now enables parties to seek to go to mediation even before filing a matter in court. Where we started before, court annexed mediation, as the name suggests, is mediation involving matters which were already in court. And either the court or the mediation deputy registrar would refer the parties to mediation. Of course, the third option was the parties themselves got to hear about mediation and then asked that their matter be referred to mediation. And very many high-profile cases have been resolved through this way. I'm sure you're all aware of the matter of Njenga Karume, very unfortunate. But very quietly, with the help of mediators, something which was turning out to be very ugly was resolved. And we believe all the parties are happy. One of the lawyers who is a member of the task force, senior counsel, John Ohaga, also helped through mediation in his capacity as a mediator to resolve a dispute between the government and the nurses, which would have paralyzed. In fact, it had initially paralyzed medical services. You may not be aware, but the truth is it was resolved through mediation. When I say we still have a big job to do, it is because of the private mediation which parties can seek without having to first file cases in court. Many people are not aware of it. So we will.
Judge, you are muted.
Can you hear me?
Yes, now we can hear you.
Sorry, there was an interruption. So I was saying we need to do a lot of sensitization, and I will be asking members of the LSK to tell their clients that, yes, you don't need to come to court. That is advice you can offer to your clients. You don't need to come to court. Your client will still pay your fees, and they can resolve the matter. And even though it be resolved outside of court, that resolution can be adopted as a judgment of the court and thus become enforceable as such. I thank you. I think I'll leave it there for now, and I'll be open to questions either now or later. Thank you.
Thank you very much, Judge, for enlightening us on the role of the mediation task force. So now we move on to the next topic and our next speaker. And for that, we are very grateful that today we have the Honorable Justice Odunga with us today. And he's going to give us a brief background of the rules and a brief overview of the court annexed mediation rules. Justice Odunga was admitted to the bar in the year 1992. He was appointed as a judge in August of the year 2011. And he has been elevated to the Court of Appeal in 2022. And he's also a recipient of the Jurist of the Year Award, which award he received in 2018. And I bet we have all interacted with his groundbreaking work on the digest on the cases. Justice Odunga, over to you. Yes, Justice Odunga, we are ready to hear from you.
Angela, I've seen a message sent to me asking me to unmute. So maybe you have not sent it to him. You've sent it to me. Just check on that.
Okay. Yeah. And now? Admin, some assistance. I don't know now whether, Judge, you are able to unmute. In the meantime, members, as we are sorting out that technical hitch, the chat section is still open. Feel free to post your comments, reactions, and questions. I'm yet to see any comments there. I'm quite sure whatever Justice Ochieng has said has been very illuminating. We can react to that.
Angela, may I suggest that perhaps as a solution is being found for Justice Odunga, if those who are present want to ask me any questions, perhaps we could continue. And then we can stop as soon as he gains access.
Yes, if you have any comment or reaction to that, you can raise your hand. We allow you to speak. In the meantime, we can take our other speaker who is also online. We have Ms. Rosemin Banji. Rosemin. Yes.
Hi, everyone.
Yes, Rosemin is our third speaker as we are working on enabling Justice Odunga to speak. Rosalind is an non-executive director. She's an experienced banker, a seasoned lawyer, a skilled adjudicator, and she's also an international mediator with about from the point of view of a practitioner, of an advocate and mediator. So she'll talk to us about how the new rules will assist the mediators in their practice as mediators, and also touch a bit about the role of advocates in mediation. Over to you, Rosemin.
Thank you, Chair. Justice Ocheng, thank you. Thank you, Law Society, for inviting me. At least we don't have a conflict that I can jump in the place of Justice Odunga, otherwise we would need mediation right now. So I think we can progress with it. Now, Angela happens to be my chair because I am a member in the Bar Bench Court Annexed Committee as well. So I will refer to Angela as my chair here. And thank you, Justice Ocheng, for giving us a very glowing tribute to the Bar Bench Court Annexed Mediation Committee. It is very much appreciated. As Angela introduced me, I think she forgot something which I would really like to share with you. And believe me, I'm not reading from any script here because Angela has not shared any questions with any one of us, or at least not me. So I will just tell you where mediation came from before I go directly to the rules and how positive I feel these rules are. I started off around 25 years ago in mediation. And yes, you can tell me I don't look my age, and I'd like to hear that because compliments are always welcome when you're over 50. But I started off mediation being appointed by His Highness the Aga Khan, and we were trained at that point in time, and I'm talking about 25 years ago, when mediation was just at the grassroots levels. And we started off as a community mediator. So I am where I am today, starting off as a community mediator. And why am I saying this? I'm saying this because there's a very critical issue which has come out in the rules which have now been enacted, and that is the issue which Justice Ocheng mentioned, and that is the issue of the private mediation being recognized. So private settlements being recognized. We have been doing it at a community level in the Aga Khan community for more than 20 years. And if I'm not mistaken, it's around between 23 years because we were trained around that time. And this will give us a lot of ammunition within the community level to resolve matters, because if the rules recognize the ability to be able to register private settlements, if the rules recognize that private settlements can be enforced, I think we have gained a lot of mileage by that. So for me, it's a very big plus. And to be honest, I'm honestly very thrilled by this. this particular development. Now, as my chair, Angela, told me to talk about briefly, and I don't want to steal the thunder from Justice Odunga, who's going to come next, I will very briefly and very superficially just talk about the new rules. And Chair, if you allow me, I will also share a few of my experiences under the Court Annexed Mediation, which I believe will sit very well within those rules and how these rules will benefit them. Because initially, as Angela mentioned, we only had practice directions. There were no rules which were embedded and which could really be flagged out to members of the public or who wanted to take advantage of mediation, or also to the practicing advocates. And I think these are really, honestly, I don't think I would be exaggerating, but I think these are a blessing for each one of us who are practicing mediators, whether we are in the court annexed highway or we are practicing it privately. So for me, and I'm talking about my personal opinion, feel free to challenge me, feel free to add or to differ with me. But I feel that the rules which now have come into force, the biggest plus is the issue of virtual mediation. And Justice Ocheng mentioned about the COVID period and about the virtual mediations. I think I managed to do a lot of work during that COVID period because of virtual mediations. And I'm talking about the locally, the Court Annexed one, and even internationally, because I think that opened a completely new window of opportunity for people who had to initially travel to go and resolve a matter. As we all know, being practicing lawyers and advocates of the High Court, that mediation is part of the alternate dispute resolution. It's one of the processes whereby we can actually resolve a dispute. So when virtual mediation came into being, it was there. But to be honest, it was really not practiced a lot. People were doing it by Skype. In the earlier days, but I think Zoom really took the fashion over. I mean, it was famed and everybody, it became the buzzword. And when Zoom came in, a lot of mediations where you could not travel, like I could not travel to Dubai or I could not travel to to the UK, but I could do and engage in mediations because of the opportunity of doing it online. And I think it's important that these rules, and I've seen it, there's a whole classification on virtual mediation. So I believe that's a big plus for all of us in the court in an annexed mediation arena. And honestly, as a court annexed mediator, I have done a lot of mediations through CAM on Zoom. So I think that's a big plus for me. The other advantage that we have under these rules to each one of us, I think I'd like to share, is the possibility, of course, of electronic filing, which is now formalized. It's part of our rules, so we can very easily file our documents electronically. As I mentioned before, the issue of private settlement, so any community-related disputes, which I do a lot of, now can be formalized, are recognized, and can be enforced. So, and actually we have got in our schedule in the rules, we have got a form by which the mediator has to sign, and it actually formalizes the private settlement. So I think for each one of us practicing, it's a big boon for us. The other thing I think the rules have also formalized is for the mediation file to be confidential. And here, I think it's very important to state that the biggest advantage of mediation, especially if it's a family mediation, is the confidentiality aspect. Why am I saying this? In a family dispute, you have siblings, you have parents, you have step-parents, you have cousins, and sometimes there is so much dirty linen, if I may use that word, dirty linen, to be washed in public. You don't want to go to an open court and talk about it. So the very fact that mediation is a confidential alternative dispute process, I think that in itself being formalized, being stated in the rules, gives a lot of confidence to the public out there, because they know with the hand to the heart that whatever they speak is going to be confidential. So that in itself is a very big advantage, and it is actually captured and embraced in our rules that the mediation file is to be confidential. So I believe that's again a huge positive and a big plus for us. As a practicing court annexed mediator, what I have realized is that initially when the practice rules were there, we used to wait and we used to say, aha, but the case summary has not been filed. How can I progress with my mediation? Yet, as we know that we have a timeline for our mediation matters, but we would wait and say, we would scratch our heads and we would go back and forth. These rules are very clear, and they said we can progress with our mediation irrespective of the case summary not being filed. So I think, again, that expedites the process. And I think the biggest advantage, whether it is court annexed mediation in Kenya or outside there, for all of us or those of us who are practicing internationally, is the speed. So confidentiality is one big positive. The second is the speed and the expediency in which you can get a resolution. For the ones who are practicing lawyers and advocates, we know how long it takes for a matter in court. It then goes to a court of appeal, Mediation, fast forward, you have your timelines, 30 days, 45 days if you'll ask for an extension, or 60 days if there is something really pressing and urgent and you can get a settlement. Advantage of speed is there. So like the roadrunner in a mediation, big positive. So the timelines are again prescribed 7 days. The forms have to be filed 7 days. Everything is very, very clearly articulated. There is no darkness there. Everything is very transparent in terms of the number of days. So it allows every practicing mediator to comply and also to explain it to the members of the public that, look, coming to mediation, apart from the confidentiality, you have got speed within maximum of, I would say, and this is my personal experience, within 60, 75 days, you can tie up your matter. You can actually tie up your matter where there is good faith and goodwill by the parties. You can very easily do it. So that is the second advantage, and it is translated and it is captured in our rules. There is something which is mentioned in our rules, and I think I would ask Justice Ocheng and probably Justice Odunga when they talk about is about the mediator's code of conduct. I am not very conversant with that, but I think probably one of the our judges can throw some light on the mediator's code of conduct. So I will just park it there. Chairman Angela, if you feel my time is up, let me know, because I'm so passionate about mediation. I can keep on talking for the next 2 hours, and I don't want to bore you. So Chair, please do let me know, as and when you want me to stop.
Rosamond, you have another 10 minutes. Maybe you can share.
Your, I will. It's very short time, but I'll try and consolidate. The biggest, or again, I keep on using the word biggest, which is not the right word, but I think another advantage in our rules is authorized representative. Now, we used to have in the practice directions, of course, members of the public are allowed to, once they file in the cases, they're allowed to bring a representative. But if you are dealing with SACCOs, which some of us have dealt with, you could have 10 members of the SACCO coming, the cooperative society, everybody wants to be heard. So this particular issue would really complicate the issue because everybody wants to talk in a mediation. So in our rules now, we are allowed authorized representatives, and you're allowed one authorized representative. And of course, there is a discretion with the mediator if you can allow 2 or 3, but again, it narrows down that scope of everybody in a cooperative society and wanting to come and, having their day, as it were. The other beautiful thing in our rules is complaints against mediators. So apart from the performance of the mediators being evaluated, because I believe that is also part of the rules, complaints against the mediators are also taken on board. So I think that regulates our family of mediators. So we can't have, as it were, rogue mediators, because you know that there is going to be a complaint which can be taken on board, which can be aired. And I'm sure there are also, again, repercussions against those rogue mediators. Again, the rules also talk about equitable distribution of cases amongst the mediators. The rules also talk about cases being allocated on a chronological order between mediators. And I believe both the eminent lordships can talk about it and throw some more light on it. So I think that is something which I would park with them. The other thing which I think I also needed more clarification, and probably each one of us, is how does the court facilitate assistance if the mediators want to use the court premises to hear mediations? And I think we would all be open to that if the eminent judges can talk about it. So that is something which we can look at that. There's also something in our rules which are talking about security arrangements being provided to mediators. And again, I'm open to hearing the wisdom words of the eminent lordships, so they can tell us about the facilitative assistance and the security arrangements. One of the most important things which I have realized when I'm doing court annexed mediation is recording. If you are doing virtual mediations, it's really, with technology being really advanced these days, people can record. And remember, mediation proceedings are confidential. You do not want any of the parties or the lawyers or the representatives to start recording. So there is a specific provision there that no recording is to be permitted. And I think it is part of the rules. So again, that's a huge benefit in preserving the confidentiality and effectively enhancing the advantages of mediation. I'll quickly draw your attention to all of us who are in this webinar today. Please look at section 26 and section 27 of the rules, because it talks about the lawyers, the etiquette of lawyers, how they're supposed to deal with these matters. Section 28 also talks about the obligation on a mediator, so that before a mediator says, no, I'm unable to progress with this case, he or she has to make every effort to try and contact the parties to make sure that they receive the notices. So again, there's a specific obligation there. To the eminent judges, section 29 talks about a penalty fee, and maybe you can talk about it when you are talking about a mediation to us. One more positive, Chair Angela, if I can talk about it, and that is a partial settlement agreement. So in a mediation, it's not either all or nothing. Yeah. Sometimes when I'm doing banking matters in a mediation, they may agree about, let's say, the rate of interest. So they may agree that if the mortgage rate of interest is, let's say, 16%, we can file a partial settlement on it. However, if the parties are not in agreement about anything in addition to that mortgage, the rate of interest, let's say there is a penalty interest or any other form of interest with the bank or financial institution is charged, you can actually enter into a partial settlement and record that partial settlement. So what really happens is that in a banking situation, in which a lot of us as mediators have done, you can say, all right, we have agreed on a rate of interest of 16% or 18%, which translates into X amount, which the borrower has agreed to pay. However, the borrower is not in agreement with the loaded interest rate, which could be a penalty rate, which is prohibitive or punitive. So then that part only can then go to court. So that is the biggest advantage. And again, that has been embraced in our rules. So I think that is a huge positive, because it is only that part of it which then goes to court. Something which I think each one of us would be very interested in mediation is the mediator's fees. And this is again my personal opinion, but I believe that mediator fees can be revived, should be reviewed upwards, because it kind of attracts more people to that profession. Because remember, mediators are not only lawyers. You can have accountants, engineers, you can have architects, you can have doctors, especially going into the mediation profession. So a lot of people are hesitant in knocking at the door and becoming a qualified mediator, because they feel maybe the fees are not attractive. So again, I'm just putting it out there on the floor. Madam Chair, please don't crucify me, but I think it is a matter of interest, which, prestige is one thing. It's good to be a mediator. It's a very prestigious profession, but remember, money is the one which makes the noise in your pocket. So I think mediator fees is one of the points we can talk about. And on that positive jingle, may I close my my short discussion today? And I hope we have all benefited from it. I'm available on email if anyone wants to ask me questions. And thank you so much. Thank you to each one of you for listening to me, Chair Angela, eminent judges, and to the Law Society of Kenya. Thank you. Asante sana.
Thank you very much, Rosemary. We still have a plenary session, so if there are any questions that will be directed to you, we shall be in a position to do that. So I'm happy to confirm that hopefully now the judge, Justice Odunga, is able to unmute. Judge, are you able to unmute now to address us? The webinar is also being streamed live on Facebook on the LSK Nairobi branch page. Now Odunga was admitted to the bar in the year 1992. He was appointed as a judge in August of 2011, and he has served in various stations. He was elevated to the Court of Appeal in September 2022. He also won a Jurist of the Year award in 2018. And we are aware that he's a published author of various legal books, especially on legal procedure, a digest of cases in East Africa. So Justice Odunga is going to give a brief background of the rules and an overview of the rules. Justice Odunga, over to you. Karibu sana. Members, continue posting your questions. We are going to have the plenary session after Justice Odunga has addressed us. Judge, over to you.
Thank you very much, Angela. Good afternoon, colleagues.
Good afternoon.
I'm sorry I joined slightly late because I was doing something else. Let me just see whether I know how to share. Am I able to share this document?
You might not be able to. Let me see whether I'll be able to give you the rights to share. Admin, you can make the judge a co-host so that he can share or enable him to share the screen. Yes, you should be able to share your screen now, Judge.
Thank you.
As the judge is preparing his screen, I'm looking at the chat section. Evans Ondusa, we shall be sure to invite you for the next session, but feel free to check the social media handles for the Nairobi, LSK Nairobi branch for updates on the next meeting. And I think even the judiciary social media handles shares updates on upcoming ins of court. Now, yes, Judge, we can see your screen and we are ready to receive.
Okay, thank you very much. I'll we'll just go through the highlights of the Court Annexed Mediation Rules 2022. Yes, these rules revoke the directions on the Court Annexed Mediation, which were pilot rules in force before the rules came into force. The rules give effect to Section 59D of the Civil Procedure Act, which deal with private mediation. That is partly, but it deals with the mediation procedures generally. I think I don't have to go through that. Now, part one of the rules deal with the court annexed mediation process, and it deals with the issue of screening of a file, which is mandatory. And there's our court annexed mediation process rather than the other forms of mediation. It's mandatory that the files be screened for all civil matters which are filed in court upon the implementation of the court annexed mediation. The screening is meant to determine the suitability of the matters for referral to mediation or otherwise. The criteria that is being used to determine which matters ought to go for mediation are such matters as the age of the case, the value and the nature of the subject matter, whether the issues for determination of the case are pure points of law, whether the case is one of a public interest litigation, of one which raises a concern, and whether the matter is a kind of a matter that would benefit the parties if the matter was referred to mediation. The appointment of mediator is dealt with in Rule 13. The mediation deputy registrar has the mandate to appoint a mediator from the registrar of accredited mediators, and that's the mediator who is supposed to handle that particular case. The deputy registrar allocates the matters equitably to the mediators, and this is done in a chronological order according to the date on which the mediator's name was accredited and added to the register of accredited mediators. Also, it may also depend on the skills, performance, experience, and availability of the mediators. Parties, however, may by mutual consent select a mediator from the list of accredited mediators, and they are at liberty to notify the parties, to notify the court accordingly. Once the mediator accepts the appointment, he or she is required to schedule a date for the initial mediation, and is required to notify the parties of the date, the time, and the venue for that particular process. Rule 16 to 18 deal with attendance at mediation. The parties or their advocates or representatives are required to attend each mediation session and also to participate in the process in good faith. The requirement for good faith therefore applies to the parties, the advocates, and the parties' representatives. Where a natural party is participating in the mediation through a representative who is not an advocate, that particular representative is required at the first session to present to the mediator a written authority. This written authority is in Form 6 and supposed to be signed by the party indicating that he or she has authorized that particular person to take part in the process and to execute an agreement on his or her behalf. And this is very important so that at the end of the process, the party does not say that it does not agree with what has been agreed upon by the representative. Where a party is a corporation, partnership, or a government agency, then a duly authorized officer is supposed to represent that particular entity. The officer must have authority to bind the entity and must attend each mediation session. And the first mediation session is supposed to present an authorization document, which is in Form 7, indicating that he or she is duly authorized to enter into a binding settlement agreement on behalf of that particular entity. Rule 26 deals with the confidentiality and inadmissibility, and it states that all communication exchanged or made during the mediation is confidential. It's therefore not admissible as evidence in any current or future cases in court unless the person is required by law to disclose the information, or the information disclosed relates to child abuse, child neglect, defilement, domestic violence, sexual offense, or any related criminal or illegal purpose. During that initial meeting, the mediator is required to execute a confidentiality form, that is Form 10, and the parties are bound by the terms of such agreement. Rule 26, we are supposed to attend a mediation session. At every mediation session, save as otherwise agreed by the parties, the following people are the ones who are supposed to attend: the parties, the dispute, and their advocates, or the parties' representatives. It's important to note that parties may agree on maybe another person attending the session apart from this, but that must be by an agreement by the parties. Now, save as otherwise agreed at the initial mediation session, each party, the dispute appearing without an advocate, has a right to be represented by one representative. And a law firm representing a party during mediation is required to allocate that particular case to a particular advocate or advocates within that firm. It's not just that the firm generally appears for a particular party, but the advocates appearing must be identified. However, with prior consent of the parties, the following persons may also attend a mediation session. That is a mediator enlisted by the Mediation Accreditation Committee who is under a mentorship program. an advocate who is holding brief for the advocate who is on record in that particular mediation, a pupil attached to an advocate on record by a party. However, not more than one pupil from a given firm may attend a case under this particular sub-rule. And once a pupil is allowed to attend, he shall at all times be in company of the master advocate. Any person attending a mediation session is bound by the rules of confidentiality, which is under Rule 25, and must at the first appearance sign the confidentiality agreement. Rule 27 deals with the roles of advocates in the court annexed mediation and provides that before or during mediation, an advocate must ensure that the party respects the notices by the mediator. It is the duty of the advocate to ensure that the clients respect the notices issued by the mediator or the court, to ensure that the clients attend at each mediation session, to explore with their clients the available options so as to ensure there's a speedy conclusion of the mediation, to adopt an advisory role, but ensuring that the party is the one who takes a lead role in the mediation session, to cooperate and encourage the parties to cooperate with the mediator and the other parties during the mediation sessions. And this will ensure that there's a speedy resolution of the dispute. Rule 28 deals with non-compliance, and it provides that if a party fails to comply with the mediator's directions or fails to attend the session, the mediator is required to file a certificate of non-compliance based on which the court may order that the parties attend further mediations. Court may strike out pleadings, make orders as to cause, and make any other appropriate order. It's important to note here that it's not simply one failure to attend that ought to lead to this particular action being taken. The mediator is required to make attempts at ensuring that parties attend before deciding to file this particular certificate. At the conclusion of the mediation process, three things may happen. There may be non-compliance. That's upon the expiry of the 60 days from the date the mediator was notified of the appointment, or the filing of non-compliance report, where the period was extended. Upon expiry of such period, the mediation process shall come to an end. Again, the parties may settle the dispute by reaching an agreement, at the end of which they are supposed to sign a mediation agreement in Form 12. The mediator is then required to file that particular agreement in court, provide each party or party's advocates or representative with a copy, and within 10 days of conclusion of mediation, a report is to be filed in Form 13. Where no agreement is reached, the mediator is supposed to notify the mediation deputy registrar, after which the case is to proceed in court in the usual manner. There are provisions dealing with setting aside an order radically arising out of the settlement agreement. Such an application can only be filed in court with the leave and supposed to be determined within 30 days of filing. There are specific grounds upon which an application for setting aside that order may be made. And these are misconduct, fraud, or fundamental mistake by the mediator relating to the proceedings in question, and this must go to the core of the matter. However, if the misconduct, fraud, or mistake complained about was known by the parties at the time of applying by the time of execution of the settlement, then this particular ground may not be readily available to the party. And that particular ground of complaint should be one which affects the process and the outcome of mediation in such a way that it would be unfair and inequitable to enforce it in that particular form. Again, the second ground could be on fraud, collusion, or misrepresentation, this time by a party to the mediation or a witness who took part in those proceedings and whose participation materially affected the outcome. There could also be a fundamental mistake by any or all the parties to the process as to the existence or state of the subject matter, a person or thing, or to any set of facts that materially affects the party's decision to enter into the subject agreement, and which has rendered that agreement unfair or inequitable. Again, where a party was at the time of making of the agreement under some legal incapacity to take part in the proceedings or to conclude and execute a binding settlement, that may be a ground for setting aside the order. Where the settlement agreement is invalid under Kenyan or international law, or it has become incapable of enforcement under Kenyan law, would be a ground for setting aside the agreement. Part 3 deals with the private settlement agreements. And a private settlement agreement binds a settlement agreement arising out of mediation process, which is conducted by a qualified mediator, but it is in respect of a dispute that is not subject to a pending court case. A qualified mediator must process a full accreditation status by the Mediation Accreditation Committee, but it does not matter whether he or she is active or inactive. He or she can also be accredited by any other institution, but that institution must be one recognized by MAC, or must possess such further or other qualification as approved by MAC, that is Mediation Accreditation Committee. Now, each private settlement agreement which is presented on this part is to be recognized by the court, and upon recognition form part of the record of the court. How are these private settlement agreements to be registered? A private settlement agreement which is entered by parties with the assistance of a qualified mediator may be presented to the mediation registry, where it was concluded within 30 days. That is after it has been signed for the purposes of registration and adoption. However, your parties are required to file prescribed fees. In presenting that private settlement agreement, supposed to be done by way of an affidavit, and that agreement is an annexure to the affidavit. However, for the private settlement agreement to be registered, it must have been reached by the assistance of a qualified mediator or mediators who must endorse the accreditation or other identifying number. It must relate to a dispute that is not subject of a pending court case. It must relate to a dispute that is capable of a resolution by mediation under Kenyan or international law. It must not be illegal. It must be one that is capable of being enforced by the court under Kenyan or international law. It must be reduced in writing in the language of the court. It must be dated, signed by the mediator, each of the parties the dispute, parties, advocates, or representatives, if any. It must indicate the place where the mediation took place, where the settlement agreement was signed. And importantly, it must resolve all the issues in dispute. Unlike the agreements arrived at under court annexed mediation, where you can have a partial settlement. The private mediation must resolve all the matters in dispute because you do not have an avenue for dealing with the matter in court with respect to the remaining issues. It must indicate concisely the nature of the dispute, issues involved, settlement agreement thereupon. The enforcement of these particular agreements. Where a party wishes to enforce an agreement registered under the Rule 48 by way of execution or otherwise, an application is to be made in Form 16, is in the schedule, and that form indicates what the party requires, the assistance that the party requires from the court. Upon receipt of this application, and separate file is to be opened, placed before the court within 14 days for adoption. However, the court may direct the parties or the mediator to be served and may direct that the party be examined on oath before the adoption is done, or the court may make such other orders it may deem necessary. Where the court is satisfied that the agreement is duly signed, means the conditions specified, it may adopt as a judgment of the court, and thereafter a decree or order shall issue. With leave of the court, a party who executed a private agreement may, but who was not heard at the time of its adoption, or any other party that feels that's affected, may apply to have that the adoption proceedings or resultant orders set aside. The aggrieved party, a party which is aggrieved by a decision arising from that particular order, may appeal the order of the court. However, that appeal ought not be one that is directed against the settlement agreement itself or its contents, but the process by which it was adopted. Now, as regards international private settlement agreements, the following is the criteria to determine those particular agreements. The dispute that is subject to agreement is one that is between parties who are national of more than one country, or where the dispute is between bodies corporate and they are incorporated in more than one country, or the central management or control is exercised in different countries, or the subject matter of the dispute is situated in a country other than the country of origin of the parties, or the country where the mediation proceedings are conducted, or the agreement is concluded, or the private settlement agreement is presented for registration and enforcement in the country other than the country of origin of the parties, or the country where the subject matter is situated, or where the mediation proceedings were conducted or private agreement concluded. However, such agreements will not be registered under these rules unless the agreement itself is valid under the Kenyan or international law and the law of the country where the mediation process took place, or the country where the settlement was concluded or executed. Must meet the requirements in Rule 46. Either of the parties must be Kenyan or ordinary resident in Kenya, or the subject matter is situated in Kenya, or the mediation proceedings were conducted and private settlement agreement concluded in Kenya, or the enforcement of the private settlement agreement is expected to be conducted in Kenya. Again, the mediation must have been conducted by a qualified mediator under the rules. However, where the mediation was conducted by a mediator who does not meet the requirements under the rules, the mediator is required first apply for recognition and certification of his or her qualification status by a mark before filing that particular agreement. I think this basically is a summary. I've not gone through all the rules, but I've just given you an insight as to what the rules provide. Thank you very much.
Thank you very much, Judge. Members, you will agree that we are in the presence of greatness because the Honorable Judge was able to condense the rules in a presentation that took exactly 20 minutes. So now the plenary is open. If you would like to ask your question directly, you can raise your hand. We shall enable you to talk. But in the meantime, there are some questions that had already been posted in the chat section, and some of the questions have been answered. Some of the questions have been answered in Justice Odunga's presentation, but we can still go through them for the benefit of all of us. And before we go to the plenary session, let me recognize the presence of Honorable Caroline Kendagor. Caroline Kendagor is the mediation registrar. So we can agree that all our issues will be answered and will be handled. Again, if you would want to ask your question live, you can raise your hand so that we enable you to talk and address this session. So back to the questions that have been posted on the chat section. The first question we shall address it to, I'll direct it to Justice Odunga. And Evans is asking whether advocates can sign the settlement agreement on behalf of the parties. And with that, maybe we can also handle Okenya Nelson's question on the acceptability of digital signatures. Maybe you handle those two before we move on to the next batch of questions. Again, members, if you'd like to ask your question live, regardless of whether you had posted it on the chat section, you can raise your hand and we shall enable you to talk. Back to you, Judge, Justice Odunga.
Sorry, I didn't realize that I was muted. Regarding the issue whether advocates can sign on behalf of the parties, I think you heard what the rules state. The parties are supposed to sign the settlement agreement. The advocates and their representatives, the parties and where they have representatives are supposed to sign. The advocate appearing for the parties are also supposed to sign. So it's not a question of advocate signing on behalf of the parties. That's the whole essence of mediation. Mediation is basically a party matter. So the party must sign the agreement, or the people who are authorized to conduct the mediation in person on behalf of the particular party.
Okay.
I hope that is clear enough.
Yes.
The issue of digital signatures. Of course, that may pose a challenge when the issue comes as to issue whether that is the signature of the particular party. But the digital signatures are now recognized as means of identification. So if we are going to have a virtual mediation, then it only follows that where we are sure that that's the signature of the parties concerned, then that can be accepted.
Okay, thank you very much, Judge. Back to the questions, there are some questions on accreditation by Nelly, and another question by Anne-Claire on the mentorship rules. Anne-Claire is wondering whether there is what entails mentorship in mediation, and she asked two questions in one, or whether a certified mediator can attend a court annexed mediation session by invitation. I will direct the questions on accreditation and mentorship to Justice Ochim.
Thank you, Angela. Actually, accreditation is the staple food for Justice Odunga. So I leave that to him. On the question of mentorship, it is something which is encouraged by us, but as has been emphasized, mediation is confidential. So for you to be allowed to participate, to gain experience in an actual mediation process, you have got to be given permission not only by the mediator, but by the parties. And you must then also make sure that you meet the requirements of confidentiality. But in principle, yes, you are allowed. This is Odunga on accreditation.
Thank you, Judge. This is with respect to mentorship. I take it. The mentorship, after you are through with your training, and you pass the whatever exam required for you to get certified as a mediator. We require that before we accredit you as a court annexed mediator, you must have undergone certain mentorship programs. We require at least 5 sessions, 5 sessions with an already accredited mediator from the beginning to the end. It's not a matter of attending a mediation today and then skipping tomorrow and then attending again after 1 or 2 days. You must be there throughout so that you know exactly the process from the beginning up to the end. So that's as far as mentorship is concerned.
On accreditation, Nelly Masaki has some concerns. She's saying that she has made her application severally and it has not been fruitful. She's wondering whether there's something that is missing in her papers. Maybe we can shed light on what exactly is required, although she has not given specifics.
Thank you very much. I think what usually happens is that when application is made, we acknowledge the receipt of the application. We go through the application, we go through the documentation. If there's anything that we require you to furnish, we tell you to furnish. If not, 2 things may happen. 1, we may be satisfied with your application the way it is, and we may not require anything else. 2, there may be issues that we may require clarification. So if we require clarifications, what we do, we arrange for some kind of an interview, just so that we clarify certain issues that may look gray on paper. Now, the problem is that due to the pandemic, we have had to deal with quite a bit of backlog because we are not able to conduct face-to-face interviews. We have already started doing that, and I think what Nelly needs to do is to get in touch with the Secretariat so that the Secretariat can give us the details exactly of the status of application is, and when we are likely to conduct an interview within her area, that is if the interview is required. So it's just a matter of getting in touch with the Secretariat.
Are there any timelines after the application for accreditation when a response is expected? This is a question by Kenneth Wahome.
The Secretariat usually responds to the parties immediately, because the response is actually by email, not by writing a letter. So what we have discovered is that and this we discovered when we are conducting interviews, is that sometimes we get the wrong email addresses on the documents. So sometimes you find that somebody has been invited for interview, he or she doesn't attend. Eventually, when he or she attends, you find that there's a problem in communication arising from the email address. But otherwise, we ought once we review the application, we do respond immediately to the applicant.
Okay, so let us switch gears a bit from accreditation, and we have a question by Nelly, a second question by Nelly Masaki on whether divorce cases can be referred to mediation. Rosemary, but I can see Justice Ochieng was very ready to answer that one. Maybe we hear you, but we'll also hear Rosemary's thoughts on that.
Okay. The very resounding answer is yes, indeed. Divorce cases are very amenable to mediation, and we have achieved many positive results.
Yes, Rosemary, before I chime in.
Yes, I just wanted to echo what Justice said, and we have been doing that even on a community basis. And I believe the essence of mediation in a divorce case again pegs on the word of confidentiality, because as I mentioned before, the issue of washing dirty linen in public, you do not want to do it in an open court. So sometimes when you do it in a mediation kind of an arena, it's more, how should I say, there is less friction between the parties. I wouldn't say friendly, because of course it's parting and disengagement of ways, but at the same time, there's a lot of dignity in that process. And just to echo what Justice said, I believe personally that it's more successful in a mediation climate than in an open court. Thank you, Chair.
You're welcome. Just to remind ourselves that even if divorce matters are referred to mediation, maybe with a view to reconciliation, because the law in Kenya is such that there is no divorce by consent. So maybe the matter can be referred to mediation with a view to reconciliation, or maybe just to calm the emotions down, but by law, there is no divorce by consent. So you cannot really agree to divorce. Maybe we need to add another ground for divorce to the current four that are there in the Marriage Act. Maybe we can have divorce by consent, but for us to divorce by consent, that would require an amendment to the law. But again, matters are referred to divorce matters can be referred to mediation, because you see, divorce, there are other disputes that there are other issues that can be handled, because this is a marriage that is breaking down. So if there is property, it would have to be split between the parties. And if there are children involved, then that also would have to be considered. So maybe other factors can be considered, but strictly speaking, there is no divorce by consent in Kenya, but other issues pertaining to the separation can be referred to mediation.
If I may just add on to that.
Yes.
Angela, you are
Yes.
so very right. It is not the process of divorce which is resolved through mediation. There are all those other issues. And remember, if a relationship has broken down irretrievably, there is no marriage anymore. What you want is to go your separate ways. You can choose one of two ways. You can choose to fight because you are so annoyed by the other person and you don't care how much dirt you throw at them in public. Or you could go with dignity, even though you are the one who was offended. Now, what does mediation do? It enables the parties to realize that if the man, for instance, is said to be a womanizer, and the wife says that he has had 7 women, but he says it's not true. But he forgets that even one is enough. So when you go through mediation, you can find instances where you are encouraged to say, look, let it go. Don't go and fight. Because if you are not rebutting things which are alleged against you, it is deemed to be uncontroverted. And therefore, what option does the court have? If it is a ground upon which the court can grant divorce, the court will have no option but to grant the divorce. But in the meantime, you will have sorted out all issues, hopefully through mediation, to do with children and property and so on. And everybody goes on with their lives without other people looking at you and wondering, my goodness, you mean that woman was that? And so on. So that's what the mediation does. Thank you.
Thank you very much, Judge. Back to the questions. James Kogie, you can do the proceedings live from the LSK Nairobi page, Facebook page. So once proceedings are being live, I think if you go back to the page, the link will still be there. Back to the questions. There's a question about the timelines for closing, submit the report. This has been asked by Evans Muriu Mwangi. And this question can be taken together with the question by Shelmith Mugo, who asked that there are cases where the parties are named such as in succession matters, and the appointed mediator may need the services of a co-mediator. How is this navigated? Rosmin, maybe you can take that, especially on the question on having many parties, because you alluded to that. Then also on the timelines, then the other panelists can chime in, but we start with
Thank you, Chair. With respect to a co-mediator, honestly, under the court annexed mediation, I have just mediated solo by myself. But in a community kind of a situation, especially when we are dealing with a situation where there was like a marriage with a possibility of reconciliation or a divorce in the offing, we would keep a co-mediator. Again, I'm talking as a community mediator for the simple reason of evening out the genders. So we would have a co-mediator there, but the co-mediator would not write any notes, because we would never write notes down as a mediator, being a confidential process, but the co-mediator would just kind of assist the mediator in the event that there is a breakdown when the parties are, the couple is before you and there is some kind of emotional outburst or something. However, I think I would ask Justice Odunga in terms of a court annexed mediator, or Justice Ochieng, because I have always mediated solo, so I don't know whether it is a practice which is encouraged or discouraged. Justices, over to you. Thank you.
Yes, over to you. Justice
Maybe the
Zedong.
Jing can go. Have a go at this one.
Okay, thank you. The rules talk about a mediator, not mediators. Strictly speaking, I don't think there would be a bar if it is requested for. But the fact that there are many people in the dispute is not a ground upon which to ask for a co-mediator. The easiest, the best way is to have that one mediator shuttling, if necessary, between the parties or sitting with the parties so that the person is helping the parties together. It is always the best. So whereas there is no strict bar to a co-mediator, I do not think that one would want to encourage it. But I see Rosemary wants to say something.
Yes, Chair, if I may, I just wanted to share something that, which I think has been brought about by Shelmith, who is talking about a co-mediator. Also remember that if you have a co-mediator in a mediation, and that again is my personal experience, you do not want to be influenced by anyone. Remember that you are listening to a mediation, you are listening, not hearing, you are listening to the party, right? And if you do have a co-mediator, which used to be there, as I said, in community matters, there can be a situation where he or she may try and have a bias or something. So I personally, with all the matters that I have handled to date, I find the success rate is higher when you are dealing with it solo, when you are listening to the parties, and at the same time also the preservation of confidentiality, because God forbid if there is any leakage, and if you're doing a family succession matter, are you going to be pointing the fingers to the co-mediator, or are you going to be pointing the fingers to yourself? So I believe that there are more advantages if you handle a matter solo and you're fully responsible and obligated to the parties. Thank you.
Thank you very much, Rosemin. Justice Odunga, we are curious to hear your thoughts on this.
Oh, thank you, Angel. I think when you have more than one mediator dealing with the matter, there's a possibility that the mediators may disagree on how to conduct the mediation process. In which case, you may end up with a dispute not now arising between the parties, but between the mediators. And unless you want to have another mediation for the mediators themselves, you better just avoid it.
Thank you very much for that. Again, members, if you would like to ask your question live or to give your reaction live, you can raise your hand. There have not been any hands raised, so I will be gracious enough to volunteer some people so that we can hear your thoughts even as we get to the next cluster of questions. And the first person whom we shall hear from is the mediation registrar, Honorable Kendago. You can unmute and greet us and accept our recognition of your presence. Honorable Kendago.
Thank you very much, Chair. A very good afternoon, Your Lordships and the lawyers fraternity. Join the conversation. Thank you very much, Angela. I've enjoyed the conversation. I think mine is just to invite feedback, participated as an advocate in mediation, or if you have participated as a mediator, or in any way interacted with the mediation secretariat, the registries that we have, the mediators. We invite you to give us feedback so we can see and continuously work on improving the support that we give you. We are grateful for those who attend the mediation mentions. It's through that we are able to conduct the active case management for the cases that have been referred to mediation. And we have shared the contacts for both the Secretariat at the Mediation Accreditation Committee and the Court Annexed Mediation Secretariat. Thank you very much. For the, if I may just mention, for the registration of the private mediation agreements, we'll be opening up new registers for those that will be filing. There are 2 ways. Those would be filing for recognition, and then those would be moving the court for enforcement of those settlement agreements. Thank you, and back to you, Angela.
Thank you very much, Honorable Kendagor. I think we are all looking forward to being able to register the private mediations. I can see there are a number of advocates and mediators on the panel. Enrica Dulo, I know you are renowned family law practitioner and an active participant in mediation. Enrica Dulo, unmute and give us your feedback on the webinar. Enrica. Enrica Dulo.
Hi, Angie.
Yes, give us your feedback on the webinar.
Oh, the webinar has been excellent. I've been listening in while on the road, so never mind. I'm afraid I cannot switch on my video, but I've enjoyed the presentations and, of course, an overview of the rules. Thank you.
Thank you very much for your feedback. Back to the questions. Evans and Usa is wondering whether accreditation certificates are still being issued, because since he's been told to wait since 2019. Then and Claire Njuguna is also asking whether a mediator in a specialized, whether a mediator can mediate in a specialized or specific field like climate change, mining, sports, or environmental disputes, or would the mediator need to be an expert on that? Before the panel answers those questions, let's hear from Sam Oma. Sam, unmute and address the questions. Yeah.
Thanks so much. I'm a mediator. I'm not an advocate. You asked for feedback. I think I'm so happy to see how active the advocates are in mediation. I want to say that the success of mediation session, some lies a lot on the advocates. In my mediation, when I find a matter that advocate supports mediation, it goes so well. So I'm so happy to see the advocates come in. I'm so happy. Over to you. Thank you.
Thank you very much, Sam, for your feedback. And reiterating the fact that advocates play a crucial role. And what you have said is actually true. Where an advocate supports mediation, the process moves very smoothly, as opposed to where the advocate is opposed to mediation, because we find that some of us actually put unnecessary roadblocks on the process. So you can find that the advocate discourages the parties from actually agreeing. But we are moving, we are doing a lot of sensitization, and so far the feedback has been great, because the mediation train has already left the station and there is no turning back. So it's up to us to encourage fellow advocates and litigants out there to actively or to embrace mediation. Justice Odumba, there was a question on whether accreditation certificates are still being issued. Maybe we hear about that.
Yes. I think. Thank you. I wish to confirm that the certificates are being issued. I think there was a time when there was a kind of a delay in having them issued, but they are now being issued. If you have been waiting for since 2019, that is rather long. That's rather long, and I think you just get in touch with the secretariat. Just do an email. You don't have to go physical. Just do an email to the secretariat, and we'll be able to check where your certificate is.
Okay. We can see our time is almost up. I'm curious to get our panelists' views on the other question as to whether for a mediator to mediate in a specialized field, you have to be trained in that particular field. And this was a question by Anne-Claire Njuguna.
If I may.
Yes.
The answer to that question broadly is there is a major distinction between arbitration and mediation. If you want to have a successful arbitration, then the arbitrator needs to know and understand the subject matter. So if there's a dispute about construction of a building, somebody in that field would make a very good arbitrator. And that is why in arbitration clauses in the agreements, it would even be put that if the parties can't agree on who to appoint as an arbitrator, maybe you will go to the institute for the chairperson to appoint an arbitrator. But in mediation, as the Honorable Chair started by saying, the greatest talent required is the ability to utilize communication techniques that will give each of the parties the power to feel they are being heard and that nobody is being looked down upon, bring the parties to feel empowered, and so to be able to come up with their own resolution. Yes, if you have some knowledge and passion, in particular more passion in that subject area, if it is children and you have a real interest in children matters, it may help. But you see, the people who are in dispute, for instance, are the adults. The subject matter of their dispute may be children. So you want to bring the adults to be able to find a solution touching on the children about who you are passionate. So if it is a question of climate change, if NEMA, for instance, is fighting with a developer, remember, we are not talking about rights in mediation. So you do not need to understand what the statutes say and so on. If they at a lawful resolution, so that, for instance, NEMA, instead of completely barring you, gives you conditions and you say, can I have more time to comply to be able then to get the okay to build, provided it's within the law, that is a person who is a suitable mediator. So you do not need specific training. Otherwise, you may end up as the judge or the magistrate from whom these matters have been taken and whose job it is to make a determination. As a mediator, it is not your job. It is to facilitate the parties to engage with each other or with one another to find their own solutions. Thank you.
Thank you very much for that. Justice Odunka, would you wish to add anything to that?
I think Justice King has put it quite well, quite well. I mean, if I'm a developer and I have a problem with my contractor, the knowledge of construction will only be able to help the contractor. Me, I've no knowledge at all about construction. The only thing I want is that you bring us together so that we agree. So you may find that you have two people from different backgrounds, and therefore your knowledge may not be able to assist both parties as a mediator. As such. So I think mediation does not necessarily require knowledge in a particular field.
Okay, so with that, let's get the closing remarks from our panelists. We'll start with Rosemin. Let's get your closing remarks.
Angela, my question is hanging in the wall.
Oh, my apologies. Yes,
Neko.
now that
Yes.
I ask a question.
You want me to come out and
Jen.
ask? It is
Yes,
written.
just ask the question.
Okay.
We are hearing it.
Yeah, I was
As I look
asking.
for
Okay, I was asking if there's a way we can be paid and know the matters that we have paid. They have paid us, because we get money, but we don't know which one has been paid.
Honorable Kendago.
Yes, Honorable Kanda.
Honorable Kendago, that is right up your alley.
Thank you very much, Mediator Neko. We have an email address that you can send us the query if you are following up on issue of payment. It's mediation. I'll share the contact on the WhatsApp forum. The payments are currently being made through what is called, you have from the judiciary. And because of the confidentiality in terms of the details that come in out of what we're able to extract from JFMIS, we are only able to give individual confirmations to our mediators. In the long term, among the strategies that we have is that once the digital strategy that we have for mediation is integrated into our financial systems, as well as our judiciary case tracking systems, and with an interface that the mediators can interact with it, then it will give you real-time prompt to alert you on which matter has been approved. And you can even track right through from when you submit the documents up to the time and which matter is being paid. Thank you.
Jen, I hope your concerns have been addressed. Apologies for the oversight. Back to you,
Accepted.
Thank you. Back to you, Rosemin. Let's get your closing remarks as we wind up.
Sure. Thank you, Chair. Thank you to the audience who has reverted with all these very interesting questions. Thank you to both the justices and, of course, to MAC for the Court Annexed Mediation. But I'd just like to end today's webinar, which I always end with three things. And this is to do with mediation. I always say when I end a webinar that there are three wise people who have said a few things. The first is John F. Kennedy, who says, "Let us never negotiate out of fear, but let us never fear to negotiate." So that's the first thing that I would share with anyone who wants to, or who is an aspiring mediator or is into mediation. The second thing, which Mahatma Gandhi said, peace is not the absence of conflict, but the ability to cope with it. So I think our mediation rules have given us enough coping mechanisms, and we can use that to make sure that the dispute is resolved to the best of the ability of the parties, because it is for the parties to craft out their own solution. And something which is there in our culture is never cut what you can untie. So don't go in for litigation, because that is going to really make sure that you are cutting the relationship. There'll be a lot of hostility, a lot of friction and acrimony. But if by mediation, it's a win-win solution, you can come up with your own home-crafted solution, then please Let's do it, and let us as mediators and as advocates who are into mediation enable it for the well-being of a community so that peace is maintained and conflict is resolved as expeditiously as possible. Thank you once again to every stakeholder here. Thank you.
Thank you very much, Rosemin, for those very wise parting words. Justice Odunga, your parting short or your parting words.
Thank you, Chair. Thank you, colleagues. This has been a very wonderful afternoon. My word goes to mediators. I would really encourage mediators to take mediation as a calling. I know that the mediators do spend I know that mediators sometimes spend, actually not sometimes, they do spend quite a bit of some money conducting the mediation. But I think we should be mindful of the outcome of mediation more than what we get from that particular process. It's really encouraging if you are able to bring two parties who are not able to agree and you bring them to agree. To me, I think that's the greatest satisfaction that you can ever get. No amount of money can be compared to that. So I think take it as a calling, take it that you are there to do service to humanity and serve those people who come to you as required, so that you try as much as possible to bring them together. You never know what the result of your intervention may achieve in future. So please, let's not concentrate too much on the amount. We know the amount is not that much, at least for now, but take it as a calling. Thank you.
Thank you very much, Judge. Finally, Justice Ochieng, let us have your final, your parting shot. Justice Ochieng.
Thank you very much, Chair. Thank you to my brother, Justice Odunga. Thank you to Madam Banji. And thank you to all the lawyers and all the mediators who have participated. It is only by talking to each other, talking to one another, that we get to learn, provided we are ready to listen. And those of us who are spoken to need to respond with sincerity. It is the only way we will help mediation grow. As my brother Judge has said, if you have a passion and if you have that talent in you to bring two people who are in dispute to be able to talk, to find, and to craft their own solution, it behoves you to use that talent in that manner. Payment for it should be a bonus. We have had mediators who have within hours brought people who haven't talked for 10 years together. And we have people who then hug and greet each other, and you wonder, these were relatives or these were business partners. Something went wrong and people went to court or something. But when they were brought together, it is like a whole new lease of life. My brother and sister advocates, I thank you for coming from where you were at years ago, thinking that mediation is an enemy, it will rob you, to now being an ardent supporter, participator, and a partner in mediation. Let's grow it together. Thank you.
Thank you very much, Justice Ochieng. On my own behalf and on behalf of the Mediation Accreditation Bar Bench Committee and the LSK Nairobi branch and the larger LSK National Office. I would like to sincerely thank our panelists, first of all, Justice Odunga, Justice Ochieng, for sharing your wisdom with us. I also sincerely thank Rosemin for giving us nuggets of wisdom and first-hand experience as senior advocate and what was the term? It was a specialized, wait, let me get the actual term. As a seasoned lawyer and a skilled adjudicator. Thank you very much to our panelists for agreeing to come and to share with us their wisdom. To all the participants, thank you for staying through the whole webinar. We have seen the comments that this can this be a monthly or a bi-monthly event. We are working towards that because we still need to sensitize all our people, even the public at large, because you see the legal system here in Kenya is adversarial. So to move people from that point where it is me against this other person to the point of mediation where we can sit and we can agree, we all need to work together as justice stakeholders, from the judiciary to the everyone and to everyone. I want to wish you all evening and enjoy the rest of your evening, and we shall be sure to let you know when we organize a similar forum. So thank you very much. We have come to the end of our webinar. Let us keep safe. The COVID numbers are rising, not to scare anyone, but let us keep safe. Let us wear our masks. Let us get tested or we get booster shots, and we keep each other safe. With that, we have come to the end of our webinar. May God bless all of us. May God bless LSK, and may God bless the judiciary. May God bless Kenya. Thank you very much. And goodbye.
Goodbye.
Bye.
Kwaheri.
Bye.
Ulikuwa na ngapi? Baba ni kuelewana.
Someone is already mediating there.
Ama ni kuelewana.
Mambo ni kuelewana.
Thank you and bye-bye.